but they're all experiencing the batteries that's flat now after this long day. But I did do the welcome, so we can start. We've got the quorum. Marcel, I did receive some apologies. So it's the first apologies member. I think Member Baha must also still be in that bus. Member Baha, Chabaleng, Kosi, and Tongeni. They will join us as soon as they reach the village. Then we also have an apology from the minister who is abroad, and then also the apology from Mr. Achilles from the Department of Justice should be present, but it's Mr. Natina, our legal advisor, who's got an apology. Is that all the apologies, Marcel?
Good evening, Chairperson, members and colleagues. Yes, Chairperson, that is the apologies.
Member Baha, are you in?
Yes, Chair.
Thanks, Member Baha. Okay, so members, that is all the apologies. Can we have a mover for the adoption of the apologies?
Chairperson?
Yes. It's Lutuli.
Yes, Lutuli moves.
Thank you, Member Lutuli. And can we have a seconder for that?
Christian, second, Chairperson.
Thank you, Member Christians. I will now hand over to the Department of Social Development.
Oh, thanks very much. Oh, yes.
The minister joined us.
The minister is here.
He's such a darling. Welcome, Minister. Let me hand over to the minister before you, ne?
Thank you very much, Peter. Thank you for being there. You know, sometimes, Chairperson, we travel and then we think maybe the connectivity might not be good, and then we give an apology. But when we try and the connectivity is good, then we get into the meeting, because we are done with our own meetings this side in Geneva for the day. So it enabled me to come to this meeting. I think that there was a thinking that maybe I might not make it due to the other meetings, but we're done with that meetings. And Chairperson, it's a pleasure for me to also indicate that we are in a very interesting meeting here in Geneva. It is about halving, that is reducing global violence, and I'm part of the task force of the Pathfinders. And it's very important for South Africa, this platform where we are in, because of what we are facing in South Africa from a point of view of violence against women and children, but also just generally from a problem of violence in general. So for us to have been asked to be part of this global initiative to see what can be done, and for us to be asked as South Africa to also be part and be sharing of our experiences, and also looking at best practices from other countries, is of utmost importance to us. So Peter, thank you very much for stepping up. I know that you were going to do a good job, but because I was able to connect, Chairperson of the Select Committee on Health and Social Services, thank you very much, as well as all the members of the Select Committee on Health and Social Services. I'm sure the acting DG is here, and senior managers and officials of the department. This has been a very long journey, if we were to think about it and look at the journey from where we started, from the time that we were asked, we were not asked, we were told by the North Gauteng court order and instructed by that court order in 2017 instructed me as a Minister of Social Development to prepare and introduce before Parliament, and I quote, a comprehensive legal solution regarding the foster care system, and I unquote. The Portfolio Committee exercises wisdom to separate the foster care related clauses from the other clauses for the purposes of meeting the court's due date of November this year, which is just not very far. And I'm sure, and I'm aware that members are aware of what happened even in the National Assembly when this report was being presented, and we are aware of the fact that there were members during the period where this was being dealt with, had to walk out and come back. I think I just want to pass the message to all the members of this select committee that as a Department of Social Development, we have a responsibility towards children in general, and therefore we unfortunately cannot afford delays when there is such legislation that needs to be passed, because we as government, but also the Portfolio Committee and the Select Committee doing its oversight, needs to hold us accountable for this, and delaying the processes would have put us in a very difficult situation in as far as the order that instructed me and the minister in particular to prepare and introduce before Parliament. We are here now, that has been done. And in my view, not only does this approach expedite the resolution of this difficult matter, and we don't take it for granted. It was a difficult matter. It still remains a difficult matter. It further facilitates the introduction of substantive and meaningful changes in the lives of children and families who were affected by the court order. And Honorable Chair and members, the clauses on which you will be briefed tonight constitute a section of 76, constitute a section 76 bill. And needless to mention, the remaining part of the initial bill will duly be processed separately. Following this approach, this does not present material issues neither to the well-being of the children nor the sector. In some great detail tonight, through Peter, who is here, I guess if I see Peter, it means the ADG is not here for now. The department will delve into the rationale and the benefit of each of the clauses in this Section 76 bill. To this end, let us be reminded that other processes and tools are already in place to support and reinforce efforts towards the realization of the comprehensive legal solution. Among these, you will recall that Cabinet approved the National Child Care and Protection Policy. Also available is the Social Assistance Amendment Act and its accompanying regulation. With the concurrence of the Minister of Finance, this came into effect for use by families on June this year, 2022. Honorable Chairperson and members, please receive the department's briefing on the clauses that are relevant to this Section 76 of Children's Amendment Act. And I take it that Peter will be the one, and I take it back to you, Chairperson, so that Peter Nechipale can be able to make the necessary presentation. And I thank you very much. I will follow up. I will be in the meeting as far as I possibly can. Thank you, Chairperson.
Thank you very much, Minister, for always availing yourself to come to the select committee meetings. We really, really do appreciate it that you make time through your very busy schedule. Peter, I will hand over to you now.
No, thanks very much, Chairperson and the members of the Select Committee. Thank you very much, Minister, for very profound introduction. I'm standing here for the Acting Director General who is not here. I'm sending my apologies. I've got members that are going to, that are accompanying me from the department. I will now take this opportunity, as Minister have said, to ask our advocate, Luyanda Mtuchisi, to take us through the presentation on the Children's Amendment Bill for you. Thank you very much. Ayanda, over to you.
Good evening, Honorable Chairperson, Honorable Members, Honorable Minister, and colleagues. Luyanda Mchochisa has been indicated. The purpose of this meeting, as has been indicated by the Minister, is to take through the Select Committee on the progress that has been registered so far with regard to the processing of the Children's Amendment Bill 2020. Which is actually a response to the comprehensive legal solution relating to foster care challenges as ordered by the North Gauteng High Court, and to highlight the rationale for each clause as the Minister has indicated. You will recall, honorable members, that this process has started for
recording in progress.
Yeah, this process has taken place for quite some time. The 9 provinces were consulted when this bill was processed. And initially, this bill contained 146 clauses and had covered all the issues relating to child protection. But for the purposes of responding to the North Gauteng High Court order, the bill was dissected into initially 3. There was the foster care issue that was put aside, and there was also the issue of early childhood development, which was also taken out of the bill that contained 146 clauses, because that process of the ECD migration had taken place at the time. So now we are focusing only on the clauses that relate to the North Gauteng High Court order. So it was just in the interest of time that the deadline set by the North Gauteng High Court order has to be met. That's why the 12 clauses initially, which ended up being 15 as consequential clauses, were suggested during the processing of this bill. So we are going to focus on those clauses, and the rest of the clauses, as the Minister has indicated, are going to be dealt with as a committee bill at a later stage. Not that they don't have any importance in their nature, but because we are focusing on the foster care issues and the court order at present. In 2017, as the Minister has indicated, the court order indicated that the delay by the first respondent in preparing and introducing before Parliament legislation amending pieces of legislation in the department to produce a comprehensive legal solution in respect of the foster care is unconstitutional, unlawful, and invalid. So to that effect, the North Gauteng High Court ordered the Minister to come up with the necessary mechanisms, structures, resources, in order to ensure that the foster care system operates in a sustainable and effective manner. And also that the amendments must be brought to all the pieces of legislation that are relevant in the department. So the first respondent was therefore directed by the North Gauteng High Court order to, within 15 months of the order, to prepare and introduce before Parliament the necessary amendments to the Children's Amendment Act and or the Social Assistance Amendment Act to produce a comprehensive legal solution. So you will recall, honorable members, that the Social Assistance Act was already amended, and the regulations there too were prepared. It is the one that the Minister is referring to that started off in June this year. So now we are focusing on the rest of the legislation, which is the Children's Amendment Bill. So in the bigger bill that was initially in the process at the time, the department identified 12 clauses from that bill which directly contribute to the comprehensive legal solution as directed by the North Gauteng High Court order. It was indicated, honorable Chair and honorable members, that these clauses are only closely related to foster care. Not that the rest of the provisions are not important, but we focused on those that are closely related, with the understanding that others are related in one way or another, but the closeness is what persuaded the department to present its case before the portfolio committee in advancing those. So these clauses provide for a legal framework that directly addresses the identified foster care challenges resulting to the North Gauteng High Court order. So they seek to strengthen the provisions of the Children's Act aimed at providing quality child protection system, of which foster care is component thereof. Just to get to the synopsis of these. So these clauses, they are around the definitions in the bill. So one of these definitions, for example, is the definition of an orphan, of which the current definition in the Act is that an orphan is one whose both parents are deceased. And this amendment is coming with a scenario that says where both parents, where both parents in the current version, and now even if one parent is deceased, that particular child will still be regarded as an orphan. So there are also other provisions that put structures and mechanisms in place, and also the issues of diversified access to legal mechanism for foster care of children, and also the issue of determining children who are at risk and who are in need of care. This bill also focuses on the children's court processes to make decisions if children are in need of care and protection, and also dealing with issues of guardianship that can also be done by the Children's Court now, which is a cheaper process than the current position that we have, where guardianship has to be dealt with by the High Court. So it also clarifies the role of caregivers within a cluster foster care scheme, which will also contribute toward the comprehensive legal solution, minimizing the confusion regarding the responsibilities of these caregivers, and making a distinction from the foster care parents that are not in the cluster foster care scheme. It also streamlines the cluster foster care provisions, thus diversifying the foster care interventions. Furthermore, the definition of a foster care scheme which diversifies the foster care interventions is also taken into account, thus contributing to the comprehensive legal solution. It must also be noted, Honorable Chair, as I indicated, that there is a definition that I've already alluded to, which talks to the issue of an orphan, where one parent has passed on, instead of the current definition that we have. So in clause 2, this amendment adds another provision of the various forms of care for children, because it addresses the mechanisms that are provided when there's a requirement by caregivers to care for children who are orphaned or abandoned, who may not necessarily require a foster care placement purely because they may require a legal mechanism to enable them to make decisions for children in their care. So this clause provides for a legal mechanism contributing to the comprehensive legal solution for foster care. It also makes this legislative provision more accessible in terms of serving the best interest of the child, which is always at the center of all these issues that relate to children. With regard to clause 2, this clause, in conjunction with clause 2, seeks to put a control mechanism to ensure that the required standard for provision of child protection services is achieved, and thus contributing to the comprehensive legal solution. It also seeks to contribute to a legislative response to a challenge relating to the required structure for the desirable child protection system. It is a required mechanism for responding to the demand for quality child protection services that include foster care scheme. With regards to clause 4, this clause seeks to address the systemic challenges by providing adequate resources, such as sufficient social workers to deal with the demand for child protection services that include foster care services, bearing in mind the limited capacity within which we operate when it comes to the resource in as far as the social workers are concerned. So it's also a tool that is required. I mean, the issue of tools of trade that are required to also ensure that there are systems and mechanisms that are put in place which are required in order to maximize compliance to the entire Children's Act that has been adequately resourced for implementation. With still on clause 4, Honorable Chair and honorable members, there is also a provision for the establishment of the child protection units, which will strengthen the comprehensive social work assessments and the provision of responsive prevention and early intervention services, thus minimizing the need for the placement of children in the foster care, because we want to ensure that the issue of backlog is addressed and the issue of new children getting into the system is also taken into account. Clause 5, honorable members and honorable chair, seeks to limit the placement of orphaned and abandoned children in the foster care of family members. So such placement are partly resulting from non-comprehensive social work assessments as prescribed in the regulations. So this is a challenge in terms of it not being comprehensive enough due to high caseloads as well as generic social work model that is prevalent in the practice in the country. So clause 5 seeks to address that challenge and come up with a solution. It also seeks to contribute to the comprehensive legal solution by addressing a symptom, which is a lack of comprehensive social work assessments of the above stated systemic challenges that I've alluded to. And that is through the establishment of child protection units by putting a specialized child protection model as a systemic mechanism for provision of child protection services. And such an undertaking will strengthen the social workers' responsibilities relating to sections 62, 155.3 and regulation 55.1 in relation to the Children's Act. So that is one of the critical children's courts processes that seeks to determine if a child is in need of care and protection. Again, Honorable Chair and honorable members, in clause 6, an approach to limit such placements, that is the placement of children in foster care, must not be construed as infringing on the constitutional right of this category of children at the expense of non-responsive social workers and child protection systems arrangements. It is the issue of the modification to this clause that are submitted to put additional control mechanisms to ensure that that children who may be at risk even in the care of family members are not automatically excluded by virtue of relationship they have with the caregiver, which is not in the best interest of the child. And again, Honorable Chair, this clause complements the amendment of the Social Assistance Act and its regulations, making a provision for extended child support grant as part of the comprehensive legal solution. Because we will understand, honorable members and honorable chair, that there are two pieces of legislation that have been developed by the department to address this issue of comprehensive social legal solution to foster care, of which the first one has already been dealt with, which is the Social Assistance Amendment Act, which has introduced the top up, which must then be read together with the provisions of this particular legislation. With regards to clause 7, Honorable Chair and honorable members, this clause seeks to contribute to the decision-making process in relation to what we alluded to in clause 5 as part of the comprehensive legal solution, because the courts have the obligation to determine whether a child is in need of care and protection when issues are being presented before them. So it also it seeks to contribute to the decision-making process in relation to clause 5 as indicated. So section 155 requires that a social worker to investigate has a duty to investigate whether a child is in need of care and protection, and part of that investigation requires a comprehensive social work assessment. So this particular clause seeks to address that challenge so that the comprehensive legal solution is realized. So this can be read again with regulation 55. This is, or that is of the regulations in relation to the Children's Act. So this is usually the case when courts make a decision in terms of whether a child is in need of care and protection as indicated. Clause 8, Honorable Chair and Honorable Members, clarifies the issue of caregivers within a cluster foster care provision, which contribute towards a comprehensive legal solution by minimizing confusion regarding the responsibilities of these caregivers, thus simplifying the cluster foster care mechanisms. In that way, it promotes compliance to the provision and diversify the scope of foster care services that are supported by the comprehensive cluster foster care regulations. And compliance to these regulations will be supported by clauses 4 and 5 in relation to these amendments and other amendments in the Act under General, because the Act has to be read in whole in order for it to be meaningful. Clause 9, Honorable Chair, seeks to provide another mechanism that addresses the mechanisms that are required by caregivers in order to care for children that are orphaned or abandoned and who may not necessarily require foster care placements, as has been indicated earlier with regard to clause 2 and 3. So these clauses also need to be read together. It also seeks to promote the Children's Act principles that seek to promote and secure stability in the child's life by considering adoption of children as the first option, so that the burden on the foster care is reduced. Clause 10, Honorable Chair, seeks to provide for another provision that addresses the mechanisms which are required by caregivers to care for children that are orphaned or abandoned that may not necessarily need foster care placements, as it has been indicated. So it has to be construed in the same context as clause 9 because they have to be read together as interconnected provisions. It also provides for the promotion of the Children's Act principles that seek to promote and secure stability in child's life by considering is adoption as indicated as the first option, and also provides a legal mechanism contributing to the comprehensive legal solution for foster care by reducing the demand for unnecessary foster care placements and serving the child's best interest. Again, Honorable Chair, in clause 10, one of the major contributory reasons to the foster care challenges is the issue of these that are systemic, the issues that are systemic, resulting to social workers' non-compliance to the legislative prescripts to extend the foster care orders on time. So this results to alternative care, that is in terms of the foster care, that is the children's constitutional rights being compromised due to the lack of enabling systemic arrangements for the social welfare and child protection systems. So this particular provision seeks to address that particular shortcoming in the existing legislation. It also seeks to enable the presiding officers to extend the alternative care placement orders in the manner that is consistent with Section 48 of the Children's Act, that is the principal legislation, because Section 48 of the Principal Act does provide for a power for the presiding officer to extend these orders in line with what Section 159 provides for. And this also contributes to the comprehensive legal solution. In clause 11, Honorable Chair, there is also an issue of clarification of the foster care, cluster foster care provisions, which will contribute towards the comprehensive legal solution. As it's been indicated earlier, that this seeks to minimize the confusion and diversifying the scope for foster care services that are supported by the comprehensive cluster foster care regulations. Compliance to these regulations will be supported in terms of clauses 4 and 5, as has been indicated earlier, Honorable Chair and Honorable Members. Again, Honorable Chair and Honorable Members, Clause 12 seeks to contribute to the streamlining the provisions for the operations of cluster foster care schemes in relation to clauses 1, A, E, and H. which are also part of the 12 clauses. That is the very first clauses in this bill. So as part of the comprehensive legal solution. In clause 13, Honorable Chair, the issue is about the challenges that are experienced with foster care in relation to the periodic 2-year cycle and extensions of foster care orders due to the presiding officer's reluctance to issue Section 186 orders. So these extensions are cyclical in nature and occur until the child turns 18. That is in turn increase the administrative processes for social workers. That further carries the risk of these foster care orders lapsing due to the systemic challenges. So the reluctance arises from the lack of the supervision of foster care placements of children in the foster care by social workers. So this clause seeks to address that shortcoming so that these cases get to be dealt with on time, so that there is no foster care that lapses in the future. It also seeks to strengthen the Section 186 provisions, which create a conducive mechanism for presiding officers to begin to issue more Section 186 orders, that is resulting to less foster care orders requiring periodic extensions of foster care orders. Again, Honorable Chair, it also seeks to, that is this provision, also seeks to strengthen the provision of Section 186 in order to make a provision for MECs to establish well-resourced child protection units and quality assurance units, which will contribute towards the comprehensive legal solution. And this will be done through a legislative requirement to address these systemic challenges by providing adequate resources, which are often a challenge from time to time, and thus putting in place the required child protection mechanisms and structures that are required. Again, Honorable Chair, this clause further seeks to establish these child protection units in order to strengthen the provision of prevention and early intervention services, thus minimizing the need for child or children being placed in foster care. That is actually what this bill, Honorable Chair, provides for, which is about the 12 clauses that have been taken out of the bigger 146 clauses. And as we related, Honorable Chair, initially, that we are mindful of the fact that a closer reading of all the provisions in the bill, they are related in one way or another to foster care, but those that are closely related to foster care are the ones that the department presented before Parliament, which are the ones that I've just presented now, which led to the A list and the B list being adopted by the Portfolio Committee in relation to these. There were other provisions that were suggested that they may be included in this list, but we indicated in our presentation to the Portfolio Committee that yes, clauses such as clause 21, clause 10, which is section 21 of the Act, which talks about the automatic rights of unmarried fathers, is a little bit problematic at this stage to include, because it also touches on the issues of custody. It on issues of the traditional leadership and issues of visitation rights, and all these issues that it relates to. They need further consultation with more stakeholders. And when this bill was presented to stakeholders around the country, there was also a challenge around the issue of automatic rights when it comes to issues of traditional or customs that we often practice in other communities, which would need this bill if that particular clause would be included here to reclassify this bill and send it to the House of Traditional Leadership, of which the opinion that was received when this bill was certified by the state law advisors, it was that this bill would not require to go to the House of Traditional Leadership. Now, if we would include such clauses, then that statement would need to change and then delay the process because November is around the corner. Not that these clauses that were omitted are not important. They are equally important, but because of the time that the attention that they deserve, that would delay us in taking this bill through the parliamentary process before the end of November, which is our target for the end of the end of this particular year. I think I must pause there, Honorable Chairperson and Honorable members, asking you to take note of this presentation. Thank you.
Thank you very much, Peter, for that. Members, do you need any clarity? I don't see any hands. Marcel Otabile, one of the two, can you take us to the process from here, please?
Good evening, Chairperson. Can you hear me?
Yes, Marcel, you can continue. Thank you.
Thank you, Chairperson. Good evening, members, members from the different provinces, colleagues, and our colleagues from the department. Chair, as you have rightfully said at the beginning of the meeting, this is the briefing on the Children's Amendment Bill, which is the first step in the 6-week cycle. This is a Section 76 bill. We have 6 weeks within which to complete this bill. From here, members of our committee would go out to their legislatures and then brief their particular legislatures, whereafter for 2 weeks, there will be public hearings in the provinces. Thereafter, Chair, there will be negotiating mandates from the various provinces till we reach the process of a final mandate, Chair. Thank you.
Thank you. Thank you very much, Marcel. Is there any member on the platform that need clarity on the process or any questions?
Chair,
Yes.
it's Ndongeni.
Yes, my dear, continue.
Okay, my dear, can I ask some questions? I'm sorry
Yes.
about my face. I'm not a robot. I am Ndongeni, but I have a problem of network.
It's fine. It's fine. You can continue, my dear.
Okay, here is my question. On the changes in the scope of children's protection, my question is, how will the department ensure that all children are protected as proposed by the Children Amendment Bill? Which is my first question. Hey, I've got a problem here in Anthony. The second one is, can the department elaborate how it will ensure children's privacy and protection of information without impinging on parental rights and responsibilities? The last one, Chair. What are the contention issues around the amendment to Section 21 of the Children's Act? How will the department address those? Thanks, Chairperson.
Thank you, Ndongeni. I just, members, to caution you, the questions on the presentation, I did not see any hands, but I'll allow you, like I allow Member Domgeni. The question that I posed to the meeting this time around was on the process, but I'll allow members, maybe we misunderstand each other. The next one will be Member Christians.
Thank you very much, Chairperson. My questions are also around section 21, the right of the unmarried father. Perhaps the department can just further elaborate on that. The gap that seems to be of great concern that was mentioned both in the portfolio committee and a week or so ago during their plenary. Then also the fact that it doesn't address unfunded NGOs, that is especially problematic in provinces, because one of the amendments I see, or one of the issues that the bill seeks to clarify, is that MECs must establish well-resourced child protection units. And this seems to leave out NGOs. So where does it speak to that anywhere in the bill? Because obviously, you know, we must also be able to, when this goes to the public, we must also be able to give them guidance on those type of issues. Then of great concern is the social worker aspect. That speaks practically clause 4, clause 5, clause 7 through to clause 13. It speaks of social workers and the mechanisms that need to be put into place. But the problem is that currently the country needs about 70,000 social workers. And I think, if I'm correct, we only have approximately 17,500. We need 70,000 social workers. How will this bill seek to address that backlog? Because without social workers, this bill will not be able to be implemented correctly. It will not, this all-inclusive children's amendment bill will not be able to be rolled out comprehensively without the necessary social workers. And with regards to the establishment of the child protection units in provinces, how will that be done? Does the bill speak to that? Are there timelines? How will that be taken care of? Those are a few of the questions, but obviously, Chairperson, we can send in other questions via written questions. Thank you.
Thank you, Member Christians. Members, I will now move over to my phone, because I will experience load shedding.
I have my hand up, Chairperson.
Member Letuli, you can continue.
Thank you, Chairperson, and greetings to everyone. Other members have covered me in some of the questions, but I also want to find out that we also know that the issue of social workers, the shortage of social workers that we have across, whether the department is planning in Am I audible?
We lost you, but you can continue.
Okay, whether the department is planning to employ more social workers in ensuring the implementation of the Children's Act, and also the issue of how is the department addressing the infrastructural challenges faced by the social workers in the implementation of the Children's Act. And also, Chairperson, the last one is that how are the adoptions adoptions cases handled by the department currently? Won't this proposed amendment cause further delays in the process? Thank you.
Thank you, Member Latuli. We've got Member Kikani next.
Thank you very much, Chairperson. I'm the Chairperson for the Portfolio Committee, Social Development here in Gauteng. I will not be engaging the presentation at this stage until I've gone through the bill itself. But I just wanted to check in terms of the process going forward. I think the presentation was made in terms of the provincial briefings. I just wanted to check what are the expectations from the briefings, from the provinces, excuse me, and also if these briefings are going to take place virtually or physically. So I just need to be taken through that process. Thank you very much.
Thank you, Member Kikani. Let me just check who's next. Is Member Engelbrecht.
Chairperson, thank you very much. I'm also from Gauteng. I just have a few questions regarding the bill. Unfortunately, I think you went so quickly that you didn't see my hand, just been up for quite a while. I'm trying to understand the difference between the child protection units versus the foster care. And I'm doing that specifically because the presenter spoke to how the child protection units will replace foster care units. So I'm battling to understand the differentiation between the two. That's the first question, Chair. Then the second one is, what is going to happen to foster care units or foster care homes? Are they not, is there no future for foster care homes? Are they going to be removed from the system? So what is going to happen to foster care units? And then there is talking of streamlining of cluster foster care schemes. Is there a difference between a cluster foster care scheme and what is meant by streamlining of cluster foster care schemes? Is that different to our current foster care homes that we currently are aware of? And then the last one is that we're talking about the expense of non-responsive social workers, which is a huge cause in the lack of adoptions. Now, if there aren't enough social workers, how is the department intending to change this and increase the responsiveness of social workers, especially taking into consideration what one of the previous speakers said, is that we do not have enough social workers. So how is the department intending to mitigate that? That on the one hand, we're saying there's non-responsive social workers. Now it appears we're giving them more work, more responsibility. Yes, we don't have those social workers that are available to do the work. And then my last question is, how will the CPU actually prevent children being placed in foster care? That was also one of the statements that were made. Thank you, Chair.
Thank you. Then the next one is Sipho.
Sorry, Chair, that's it was just an error. My hand is not supposed to be up. Thank you very much.
Okay, thank you. Let's welcome the members from Northwest Province who has joined us. The next one is Siki Konza.
Thank you, Chair. Good evening, Chair and the Minister and honorable members. I am Siki Konza, from the Chairperson of the Eastern Cape Social Development Committee. Mine, Chair, I think I have been covered slightly by Honorable Kekana on the issues of the process. But I want to check in relation as to that, as to whether there are timelines or specific times exactly in relation as to the process itself, the 6 steps, especially those that are affecting the provinces, like the public hearings and the going to the legislatures by the NCOP. I'm asking this, Chair, because we have at the level of the provinces to allocate into our own programs of the legislature or request slots in relation as to the allocations for those processes. So it would assist us if we could be clear if there is any clarity yet in relation as to when they will be happening. Thank you very much.
Thank you, member. We've got member Swartboy. Swartboy will be the last person.
Thank you, Chairperson. Good evening, Minister and Chairperson and all the honorable members. Chairperson, I just want to get clarity here. I just saw on the charts, if you can check the charts, I think it's a Kuzwayo who was asking whether the presentation, is it an old presentation? Because I also saw that when the presentation was done, that clause 13 in the bill is amending section 185. But what was being presented here was not concurring with clause 13. Secondly, according to the presentation went up to clause 13, but the bill ends in clause 16. Can I get a clarity there?
Thank you. My apologies for not switching on my video. I've got load shedding. I will first hand over to Peter and his colleagues in the department, or if the minister is here, to answer the clarity-seeking questions on the bill. After that, I will allow Marcel to explain the questions that was asked by the different provinces. Thank you.
Thank you very much, Chairperson.
Chairperson, may I, Peter, just a quick one, Peter, before you answer. Thank you very much to the members for all the questions that were asked, and I will hand over to Peter and the team to answer the question, but to also indicate, Chair, that the presentation, particularly today, was focused, was properly focused according to the request. It was focused on on the clauses that we covered. If in case there are clauses that members feel maybe were not explained outside of the ones that were presented here in terms of what we even presented to the National Assembly, I would ask that where we are unable to respond, but I know the department is able to respond, but if in case there are areas they're not able to respond to, can we then respond that also in writing? Thank you, Chairperson, and over to you, Peter.
Thanks very much, Minister and Honorable Member, and thanks very much for the questions that have been asked. And I think a Minister has already alluded the issue that in cases where some of the questions are not answered, we will send the response in writing fully to the members. There are certain clarity-seeking questions that I will ask members, Luyanda Mchochizi and Tekuse, to take through. But I think let me start with the bigger one, the issue of the appointment of social workers and the social workers that we don't have enough. Indeed, it's a fact as a department, that is a journey that we're going through to reach the target that we have. And I think as a department, we have developed a strategy and what that has been presented, National Treasury, and also a collaboration with other government departments for the appointment of social workers that we have. And I think we are very optimistic that we will be able, each year we will add the number of social workers that we require in all 9 provinces. With regard to the specific questions that need clarity, may I ask Advocate Luyanda Mchochizi to take us through some of the questions. In cases where you can't provide that, we will indicate that we will send the responses in writing. Over to you, Mchochizi. Then in other areas, when you finish, Mchochizi, we will then ask Madam Tsekiso to take us through some of the clarity-seeking questions. Thank you very much. Ayanda? Luyanda?
Okay, through your chair. Through your chair, the issue around the question of Section 21, if I may start there. The intention of the department when it introduced the amendment to Section 21 was in relation to Section 9 of the Constitution, to say no one may be unfairly discriminated based on marital status. We took that into account to say unmarried fathers must not be discriminated by virtue of being unmarried. And they would need to have a role to play in the lives of their children. But the understanding of this provision has been blown out of proportion in terms of the number of comments that have been received around it. To say, let us also include issues of custody, issues of visitation rights, and there has also been an impact on traditional leadership. And we said around this, the challenge in dealing with these, some of these, we are not able to legislate on as a department. For example, issues of custody, because the commentary was around extending these to take into account automatic custody of children during divorce cases and such other instances. And we said the challenge with this is that we need to engage further with the Department of Justice, because if we are going to talk about automatic custody, it's going to be a challenge because courts have a role to play in regard to determining the suitability of a father to have custody of children. So it can't just be automatic. That is why we as one not including it in these provisions. It's because of that reason. There is a need to include the Department of Justice to deal with that particular matter. And we must be mindful of the fact that as Parliament, we are aware of the functions of the other arm of government, that is the judiciary, and we cannot be seen to be usurping the powers of the courts, because it is the courts who have got a power to determine on the suitability of a parent to have custody of children. Same applies as the issue of visitation rights, which cannot just be automatic, because that is the nature of the comment that we received, which cannot be automatic upon parents divorcing. And also the issue of traditional leadership. We had indicated that we have not consulted with the House of Traditional Leadership as required by the rules of Parliament, that when the matter affects the traditional leadership, we need to consult with the House of Traditional Leaders, because according to the commentary that was received, there was also a need to look at the issues of the payment of damages before a person who has impregnated one's daughter can have access to a child in that particular family. So these are the issues that we needed to clarify before we can legislate correctly on this particular aspect, which would need us to spend more time on consultation, and which would affect the time that is left for us to comply with the North Gauteng High Court order. Not that this matter is not important, but because of the time that is needed and further engagement. With regard to the issue of protection of children, yes, the bill does, just like the Children's Act, the bill intends to protect children. There's the whole issue about the Children's Act is about the child protection in general. So the bill is actually working on that with regard to the issue whether this bill does protect children. And with regard to the issue of privacy of children. It's also part of the remaining clauses of the bill, where we have indicated that with regard to issues of privacy, there are so many laws that are already covering that aspect. When we legislate, we need to be aware of existing legislation so that we don't duplicate laws. We harmonize pieces of legislation. We do have the Protection of Information Act. We also have the BOPIA that has also been passed not so long ago. So whenever we deal with issues of protection of privacy of children, we take those into account. So again, with the issue of adoptions, yes, we say indeed, as we indicated, that there are clauses that may also be linked to foster care, but these clauses are not directly linked. There is a process that needs to be followed with regards to issues like adoption, which may take a very long time. So all these other clauses will be dealt with in a bigger bill. So the other parts, or with regards to the issue of the clauses, that the 15 or the 16 versus the 13 that we originally had, some of the clauses were brought about by consequence. There are clauses that when the A list was proposed that needed to be included. For instance, the issue of Section 45 to read together with Section 44, which the members of Parliament agreed that that part needs to be included. So when we spoke of 13 or 12 initially, these are the clauses that the department had identified, but over and above those, the parliamentarians in the portfolio committee debated on those, and there are clauses that came about as a consequence. There was also another one, which is the amendment of Section 160C capital A, which talks to regulations, which was also not part of those that were introduced. So the number has been increased by consequential amendments. I think for now I can pause there, Honorable Chair, and give over to my colleague, Mr. Giso. Thank you.
Okay, so on the areas that have been asked by members that you need to clarify, over to you, Nellis.
Thank you, Mr. Nechipale. Good evening, Honorable Chairperson, Honorable members, and Honorable Minister, as well as colleagues. I will be responding to the child protection units questions that were raised. In relation to how long will it take for these child protection units to be established. I think I must just indicate that this process is highly dependent on the development of the regulations, because the regulations are the ones that actually unpacks on how these child protection units will function. But I must indicate that the child protection units are actually, proposed on the basis of ensuring that we intensify prevention and early intervention services, which requires quite a number of, cadre of social service practitioners, not necessarily social workers. And that also includes, the child protection organizations that will be rendering these child protection services. And as Honorable Engelbrecht was asking the difference between the child protection unit and foster care units. The child protection units are actually an umbrella of all the child protection services that will be rendered. And foster care, it's one of those that will be rendered within the child protection units. And the reason we are saying that, it will also minimize the flogging of the foster care system, because a thorough assessment will be done, ensuring that all children are channeled into different programs that they need to attend to, not necessarily going into foster care placement. That is why we are saying that the child protection units with their establishment will really prevent children being diverted into foster care, because of non-comprehensive assessment that normally takes place. So no child will be lost within the child protection system or fall within the cracks, because there will be close monitoring of those children that are within the child protection system. And another thing that I think I need to clarify is asked by Honorable Member Engelbrecht. It's around the issues of the streamlining of the foster care schemes. And I need to indicate that we have observed that the foster care schemes are not fully utilized in terms of, in accordance with the prescripts of the Children's Act. As a result, you find that sometimes when organizations are not complying with the requirements of child and youth care centers, they tend to make those facilities foster care schemes, which is not compliant with the prescripts of the Children's Act. Therefore, this provision is intended to strengthen the application of, the concept of cluster foster care schemes, so that your provinces implement the cluster foster care schemes as they are intended. As Minister indicated, some of the questions we will provide through written replies. Thank you so much, Mr. Nishipale. Thank you. Back to you.
No, thank you very much, honorable colleagues and honorable members. Can I hand it over to our minister for the chairperson?
Peter, just before the minister on the chat, there is a question from the legal department from Free State. If you can just check the chat.
Okay. Yeah. Okay, yeah, there is question 8. It says, Chairperson, there are 3 versions of the bill that were circulated: B18/2020, B18A/2020, and B18B 2020. Which bill is the bill intended for today's meeting? Legal Advisor, Free State. Yeah, I got that. Advocate Mchochiso.
Through your chair, Mr. Nishipale, the bill that we are referring to today is B18B of 2020. Remember, the 18A would be our A list and the B would be our B list, which is the final version that has been debated. Thank you.
Thank you very much. Chairperson?
Okay, Minister, do you want to come in now, or must I first allow the staff to answer the logistical questions?
I think it will be better for them to deal with the logistical questions, Chair, because I guess that's also part of the process, and the process must be very clear. Thank you, Chair.
Thank you, Minister. Tabile or Marcel?
Thank you, Chairperson. Again, good evening all. Chairperson, to my understanding, I am going to answer that question in terms of the program that our committee has drawn up to process this bill. In terms of the Select Committee on Health and Social Services, this particular bill, the B version of the bill as we are dealing with, was referred to our committee on Tuesday last week. This is the version of the bill that we are working on. With that said, Chair, this is the first meeting of the 6-week cycle. The first meeting, which is the briefing by the department, which we are having today. The next step in processing this bill is, Chairperson, where the members of our committee will go to their legislatures and brief the legislatures on this particular bill. This will be done in conjunction with the assistance from DSD in briefing your legislatures on the bill. Chairperson, the following 2 weeks, the various legislatures will hold public hearings in terms of public participation on this particular bill. The legislatures, they would obviously have a program for where and when they are holding their public hearings, in which areas. From those public hearings, Chair, a negotiating mandate is then formed at the legislature, which then comes back to our committee. That is step 5. In step 6, Chairperson, we finalize the bill where we get a final mandate from the legislatures in completing this bill. That is the 6-week cycle, Chairperson, if I'm clear.
Thank you, Marcia. Just also the answer to the question, if it will be virtual or physical, that is something that can be discussed between the members from the select committee and then the legislature. Thank you. Minister, I will hand over to you now.
Thank you very much, Chairperson. May I take the opportunity, because I need to log off also. May I take the opportunity to thank you and for giving us the opportunity, and thank the members for their questions, including those that connected to the provinces. But I will leave it to Peter Nechipale if in case there are other things that the department would like to say, and may I please graciously be excused from the meeting. Thank you, Chairperson.
Thank you, Minister. Thank you for your contribution, and you are excused.
Thank you.
And I know you will represent us well that side. Members, is there any other clarity seeking questions?
Chairperson?
Yes.
Chairperson, may I plead with the select committee that the people who will be doing presentations to the provinces, can they have one bill then, so that we cannot be confused? Because that's why I was confused. Because there are 3 versions of the bills of the bill that has been received by us. So that's why I was also confused. So if they come to provinces, they must do presentation on B18B dash 2020 bill. The presentation.
Thank you. Thank you. We will do that. We've got our legal team of Parliament and of the department that must make sure that it's the correct version of the bill that will be presented to the legislators. Thank you, member. Peter, anything else?
No, Chairperson, I just want to thank the Chairperson and the members for their contribution, and thank you very much for being such responsive. And also need to thank the TSD team and the select committee team that organized this briefing session. Thank you very much, Chairperson. It's nice to be with you all the time.
Thank you. Oh, I'm struggling with this phone. No, that is fine. Let me also then take the opportunity to thank the department and the minister, also the legal department from Parliament, all our members, all the members from the different provinces that is on the platform, as well as our staff. Thank you for the hard work that you put in this few days to make sure that we've got this meeting tonight. I know our members are very tired because we've got a very difficult week in front of us. But thank you, members, for all of you for availing yourself to be part of this meeting. With that few words, I declare the meeting closed. Thank you.
Thank you very much.
Thank
Thank you,
you.
Chairperson.
Thank you and good night, everybody.
Good night.
Thank you.
Thank you, Chair.
Thank you, Chairperson.
Thank you, Chair.
Thank you. Good night.
Good
Good
night.
night.